Good evening. My name is Rachel Murphy, and I'm going to speak with you tonight about the death penalty. I have done extensive research on the punishment, and you may be surprised to know that at the beginning of my research, I was pro-death penalty. This subject is literally a matter of life or death for people. Several states recognize this and have either abolished or placed a moratorium on the use of the death penalty. The governor of Washington State, Jay Inslee, was the latest to place a moratorium on the penalty, stating in his speech announcing a capital punishment moratorium 2014 that he would not sign a death warrant for his time in office. This did not end the death penalty in the state, but placed a hold on the use of the punishment. This raises the question if the death penalty should be used by any state, or should other states follow in the footsteps of Washington. Can you end the life of a human without making them suffer? Does our justice system still operate using outdated punishment methods? Does sentencing a criminal to death actually provide closure for the victim or their family? American citizens are governed by the Constitution, which dictates our laws. The law does not support the use of the death penalty because the Constitution's 8th Amendment bans cruel and unusual punishment. An example of a blatant 8th Amendment violation would be the botched execution of Clayton Lockett in Oklahoma, one of only 3 executions on record to have been halted. Lockett's was halted due to vein failure. According to a September 2013 article by Kate Fretland in The Guardian, enough of the drug cocktail had entered Lockett to cause a reaction, but not enough to cause immediate death. He suffered for over 40 minutes before succumbing to a heart attack. Another case of blatant cruelty would be the case of Rommel Broom. On September 15, 2009, Broom was scheduled to be executed by the state of Ohio. After 2 hours, the execution team could not find a suitable vein to place the needles for injection. The execution was called off, and stays of execution were granted for 1 week. Broom is actually currently still awaiting a ruling on the constitutionality of a second attempt on his life. This picture is Rommel Broom. It was sourced from deathpenalty.org. It was taken after the execution was halted. He was actually injected over 40 times before they stopped trying to end his life. The government has responsibilities to the people. One of those responsibilities is to spend tax dollars in a responsible manner. Capital cases where the death penalty is a viable option are often more time-consuming and taxing on an already crowded justice system. The cases also provide to be more costly to taxpayers. In Washington State, a Seattle University study that was printed in the January 7, 2015 edition of the Seattle Times showed that the death penalty cases cost $1 million more than similar cases where the death penalty was not sought. Law enforcement and the government have long stated that the death penalty is a deterrent. However, there is no solid data to show that the death penalty works as a deterrent. In fact, the Committee on Law and Justice concluded in their 2012 research on the effectiveness of capital punishment on homicide rates is not informative on whether capital punishment decreases, increases, or has any effect on homicide rates. Therefore, the committee recommends that these studies not be used to inform in deliberations requiring judgment about the effectiveness of death penalty on homicide rates. One thing should be clear. People with a diagnosed mental deficiency, whether it be an intellectual disability or insanity, are not put to death in the United States. However, a person who needs medication to control a mental illness is not afforded that same protection. The 2003 United States Supreme Court case of Sell v. the United States, the court imposed stringent limits on the right of a lower court to order a forcible administration of antipsychotic medication to a defendant determined to be incompetent to stand trial for the sole purpose of making them competent and able to be tried. Specifically, the court held that lower courts could only do so under limited circumstances in which specified criteria had been met. Mental capacity is a huge debate in the death penalty, about the death penalty. Up until the early 90s, the state of Texas, who leads the nation in the number of prisoner executions, did not allow jurors to factor in mental illness. The Supreme Court ruled in the case of Atkins v. Virginia in 2002 that executing people with intellectual disabilities violated the Eighth Amendment. Although states can define who is intellectually disabled. These loopholes in the law between state and federal guidelines for mental capacity leave huge gaps in the ability of states to execute mentally incapacitated people. But what about the victims? The goal of our justice system is to provide closure to victims and their families. Allowing a victim or their family to move on after a crime has been committed is important and often used as a rationale for the death penalty. Murder cases where the death penalty is a viable option can take much longer than life in prison trials, and victims' families are often frustrated at the sluggishness of the justice system. According to the Death Penalty Information Center, death row inmates can spend decades waiting for the fulfillment of their sentences. Whether this time certainly seems long for an inmate, the survivors often spend time worried about appeals being granted and the accused being freed. A 2012 study between two professors, Amore and Umbret, showed a stark contrast between families of victims in Minnesota, and where there is no death penalty, and Texas, which leads the nation in prisoner executions. The studies found that families in Minnesota showed higher levels of physical, psychological, and behavioral health, as well as more satisfaction with the criminal justice system. This study suggests that closure for victims or their families is often achieved more easily through life without parole sentences. In summary, the death penalty has been around for thousands of years in one form or another. Capital punishment is more expensive, has been shown numerous times to be ineffective, has proved to be inadequate in deterring crime, is cruel and unusual punishment, and is unfairly used among the poor and mentally disabled. The death penalty is a drastic option when people who commit crimes can be rehabilitated to the fullest extent and become as useful as possible to society. Finally, and maybe more importantly, the death penalty does not provide meaningful closure for victims or families, which is the ultimate goal of the justice system. One death is one too many. Thank you very much for your time.